as we're getting close to the end of the rule,
Yeah.
now that we figured out when you should be asking for costs, when you shouldn't be asking for costs, what will the court look at in deciding whether to order costs or not? Then you get down to the nuts and bolts, and we've kind of slid into the sideways a couple of times earlier.
Yeah.
About how do you figure out what is the amount of costs that a court should order? What can you expect? That's section 24, sub 12. So sub rule 24 sub 12 says that when setting an amount of costs, and it's got a whole list of factors the court is required to consider. So again, it's going to get boring because I'm going to read through them. The court shall consider A, the reasonableness and proportionality of each of the following factors as it relates to the importance and complexity of the issues. B, each party's behavior, the time spent by each party, any written offers to settle, including ones that don't meet the requirements of an official offer to settle. Any legal fees, including the number of lawyers and their rates. Any expert witness fees, including the number of experts and their rates. And any other expenses properly paid or payable. And then there's the catch-all, any other relevant matter. So that's when you get into saying if you're then bringing up an allegation of bad faith, then that's where you would have to bring in all the stuff that you're asking the court to consider to find that there's been the bad faith is made out, which means you could be looking at getting costs on a full recovery basis. As I said, does not happen that often. Again, because one of the other things that the courts have to keep in mind is the balancing act, because they're saying we are encouraging parties to settle rather than litigate if it's reasonable to do so. Sometimes both parties could be taking a legitimate position, and it's hard. That's why we have judges to make the hard decisions. Neither party is 100% right and the other party is 100% wrong. It could be just balancing ultimately who's going to be successful, and either party could be successful because they've each got arguments going in their favor. But then it's the whole question of saying but then how do you determine costs afterwards? If it's really, really close, it could have gone either way. The court always has discretion to not order costs at all. And if they are going to order costs, they can make it in an amount that isn't what is being asked for. And as I said, the ultimate weird thing that can happen is that even if you're the successful party, if you've been the unreasonable party, even though you ultimately won, you could actually, not only get an order for costs against the other side, court can order you to pay the losing side costs. But again, that doesn't happen very often, but it can. Okay, the bottom line is again, so all of this is done by way, I said at each step of the proceeding, those are generally done by oral submissions. Like it's just, okay, you've completed your motion. Right. Unless the judge specifically requests written submissions as to costs, quite often you'll just ask for costs verbally. If the judge wants you to come back to court to argue costs another day because you can't agree to the costs, you could be asked to do that. But the costs get settled at every step of the way. But if you're at the point where, let's say it's at the conclusion of a trial, and there's one successful party and the unsuccessful party, then, as I said, what's more common than not is the judge will make an order saying that the applicant or the respondent, and you can tell by who they name is who the judge thinks is the successful party, is to submit their bill of costs first, and then the other side gets so many days to do their own responding bill of costs.
Right.
And then if they have to come back to a judge because they can't settle the costs between them based on the bill of costs, then there'll be a hearing on what the costs should be. But again, keep in mind that when you're doing that kind of claim for costs and you're being asked to file written submissions, you have to have all your supporting documentation. So if you've got expert reports and that kind of stuff, you need to produce copies of the invoices to show and prove what your disbursements are. And lawyers' time, quite often what they'll do is they'll do dockets, and they will make their dockets part of the bill of costs. But again, there's a real dispute about how you do that, because the dockets that you do for managing your file in your office is not what your docket should look like that you're filing for the purposes of a bill of costs, because there's a lot of stuff that might be contained in your docket information. Like, for example, the most common thing, the most straightforward example is, for example, if a lawyer introduces a docket, says, I spent 38 hours acting for the client on this matter, and here's the docket of all the services I've rendered. The actual file docket could say telephone call to client to discuss sexual assault by a respondent, which occurred on this and this day, to discuss client's options. That's what the lawyer's docket actually says, recording what that call was about that day.
Yeah.
For the purposes of the bill of costs, what you should probably be considering as the lawyers just say, this day, telephone call to client. And you don't talk about what the contents of the conversation were,
Yes,
because a lot of that might be confidential, privileged information. And the court isn't going to care if you just have your docket that just says, yep, on this day, I spent 25 minutes talking, telephone call the client, 25 minutes. That's
So
all you need
basically
on your bill of costs.
redacting the docket.
Yep.
Yeah.
There actually now are software programs out there that a lot of law offices use that will do a docketing function. So it's just as you're performing services for your client, you just enter it in and it starts a timer and it ends the timer and you type in what you actually did. And then when you are actually adjusting, like when you're taking that docket and you're setting it up to be incorporated into a bill of costs, it will automatically take out the stuff that should not be going to the other side or before a judge.
Okay, you mentioned the term cost submissions, and as we were talking off the record before, I tried to look up on the family law rules forms, and there is no form that says cost submission. So, what kind of format should a person use for cost submissions? Is it similar to that of the civil litigation side?
There are a lot of people that use that as their template for making submissions in family corporate, and there's nothing wrong with doing that.
Oh, okay.
But it is not mandatory. It is not required. It's the same thing like for there is no template for a bill of costs either in family law proceedings. So a lot of it you might be out there on your own, but even if that makes you feel horrible and think, oh my gosh, maybe that's why you get a lawyer, because they do it. Like there are a lot of conversations that go on between lawyers that help out their colleagues and stuff like that. And like trading of information and trading precedents and templates, say, okay, this is what I use. And it serves me really, really well. But yeah, it's very unique and it's individualized, and there is nothing that you can get sent to say, look, here it is, just fill in the blanks and away you go. It doesn't, unfortunately, there's no form.
Well, maybe a word of advice here to our self reps is that they could go to that family law, the one that you were leading. What is the name again? Family law.
Well, the limited scope services project.
Yes, that one. They can go there and hire a lawyer on limited scope for this purpose.
They could
help them.
But I would. No. Yeah, it's interesting. I don't know for the return on investment.
Oh.
If you're a self-represented litigant trying to do your own bill, I think your best step would have been to get the lawyer for the step that got you to the point where you've actually got a successful bill of costs anyway. Oh, but yes, you could. Course. You might be able to find a lawyer who would do that for you. Okay. And again, what you will find is that there are lawyers have different levels of experience in dealing with bills of costs and how to set them up. There are some law firms that crank these out dozens of times a week. There are other firms that might do it only 2 or 3 times a year. So yeah, it really is a question of finding the right fit, and if somebody is willing to do one for you on a limited scope services basis.
Well, the directory is there for in case somebody wants to.
Yes.
Yeah. Okay.
And the other, again, website that I refer a lot of people to whenever you're dealing with family law issues is the Steps to Justice.
Oh, yes.
Website by CLIO, Community Legal Education Ontario.
Right.
It actually has a section as well that talks about costs. I don't know if they have any templates or precedents, but again, a lot of good information and stuff on what you should be looking at if you are planning on making it. But especially like with self-litigants. Yeah. Unless a court specifically orders you to produce written submissions and sets a timeline for when you have to serve and file on the other side, and then you've got so much time to work it out, and then if you can't, you come back to argue it. A lot of the cost submissions happen just standing on your feet as soon as the matter is dealt with. And as I said, every litigant, whether they're self-represented or not, should be thinking at every step of the process saying, was I the successful party on what we just did, or was I the loser? And if you're the successful party, you should be thinking about costs and at least raising it to the judge. There are a lot of judges that they'll just, especially when they're dealing with 2 self-represented litigants, they're going to say, look, these people really don't understand the rules. They don't understand the concepts of what they're dealing with. My concern is to make sure if there are children involved, that the best interests of the children are being met. And these parties both are trying to do what they think is the right thing. I'm not going to make an order for costs. So but again, it never hurts, and a judge will never get angry with you for they might get a little bit irritated, but it's just, again, I would always make that submission about saying, Your Honor, I was a successful party today. And again, the reasons why you should get your costs, which are all the things we talked about, was the other side unprepared? Have they breached orders? Have they not done what they were supposed to do? Were they not prepared to proceed today? say all those things and just say, Your Honor, I'm asking for an order for costs. And then
That's
it's
so
still up to the judge to
important,
say,
yeah.
no orders, no order to costs as of today, or costs are reserved, or yes, I am
Yeah.
going to make an order for costs and I'm fixing costs in the amount of X. So,
It's
yeah,
so interesting because I'm thinking about my personality is I'm very kind of shy-ish. Like I wouldn't even think. I mean, I would be thinking so much, of course, focusing on winning the motion or whatever it is substantively. But I wouldn't even be thinking about um, asking for costs. I don't know why. It just makes me feel uncomfortable. But then you're saying that really you should be assertive enough to ask for costs if you're the successful party, rather than assuming the judge would just give it to you. Like.
no, and that's exactly why you'll see that in a lot of the templates that different lawyers and law firms will use,
Yeah.
when they're dealing with the opposing party, either through counsel or a self-represented litigant, if they are requesting a consent to an order for something,
Yeah.
they will always set it out. They will generally enclose an offer to settle.
Yeah.
And the covering letter will say, look, this is an issue we have. This is what we're proposing to settle this issue on a temporary basis or final basis or whatever.
Mm.
And here's our offer to settle. But we are advising you that if you do not accept this offer to settle, then we will be bringing a motion. And if we do bring a motion, we will be claiming costs. Because we could have got this dealt with right here. We shouldn't have to go through that nonsense.
Okay, sounds good. I'm actually done for my questions. Do you have any wrap up last words?
No, again, just
Good.
basically reminding everybody that you should be thinking about costs at every stage and don't be shy to ask for them. The worst a judge can do is say no, but you'll never know until you try.
Well, thank you so much, Helena, for coming in today. This is really important information for everyone. And thanks for watching. And if you're new here, don't forget to like and subscribe, and also share it with your friends if you find that there are people who need this information. And hopefully we'll see you at the next video. Thank you. Bye-bye.
Thanks, Heather. It was fun. Take care.
Bye.